Question 1. In California, which government entity is primarily responsible for issuing concealed carry weapons, CCW, permits? A. The California Department of Justice, DOJ. B. The local sheriff's department or police chief. C. The California Highway Patrol, CHP. D. The Federal Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF. Answer: B. The local sheriff's department or police chief. In California, the authority to issue concealed carry weapons, CCW, permits rests with the local licensing authority, which is typically the sheriff of the county or the chief of police of an incorporated city where the applicant resides. This decentralized system means that the specific application process and requirements can vary slightly from one county or city to another, although all must adhere to state law. Understanding your local issuing authority is the first step in the CCW application process. Question 2. What is the minimum age requirement to obtain a concealed carry weapons, CCW, permit in California? A. 18 years old. B. 20 years old. C. 21 years old. D. 25 years old. Answer: C. 21 years old. To be eligible for a concealed carry weapons, CCW, permit in California, an applicant must be at least 21 years of age. This age requirement is a fundamental criterion set forth in state law, similar to the age for purchasing a handgun. Always ensure you meet all foundational eligibility requirements before beginning the application process for any firearm permit. Question 3. Under California law, a person applying for a CCW permit must be a resident of which area? A. The state of California for at least 1 year. B. The United States of America. C. The county or city where the application is submitted. D. Any county adjacent to the one where the application is submitted. Answer: C. The county or city where the application is submitted. A fundamental requirement for obtaining a California Concealed Carry Weapons, CCW, permit is that the applicant must reside in the county or the city where they are applying. This ensures that the local law enforcement agency, whether the sheriff's department or police chief, has jurisdiction over the applicant and can properly assess their eligibility based on local knowledge and records. Always apply to the correct local authority where your primary residence is located. Question 4. What is the maximum initial validity period for a standard California Concealed Carry Weapons, CCW, permit? A. 1 year. B. 2 years. C. 3 years. D. 5 years. Answer: B. 2 years. A standard California Concealed Carry Weapons, CCW, permit is generally issued for a maximum period of 2 years. However, if the permit is issued to a judge or a peace officer, the validity period can extend up to 4 years. For most private citizens, understanding this 2-year initial and renewal cycle is crucial for planning training and reapplication processes to maintain continuous licensure. Question 5. Which of the following is not typically a prohibited location for carrying a concealed firearm, even with a valid CCW permit, under California law? A. Within 1,000 feet of a K-12 school. B. Federal buildings and courthouses. C. Inside a private residence with the owner's permission. D. Polling places while an election is underway. Answer: C. Inside a private residence with the owner's permission. Even with a valid CCW permit, California law designates many places as gun-free zones, where carrying a concealed firearm is prohibited, such as K-12 schools, federal buildings, and polling places. However, carrying inside a private residence with the owner's permission is generally not one of these prohibited locations, as long as other laws are followed. It is crucial to be aware of the numerous specific locations where your permit does not grant you the right to carry. Question 6. What minimum number of hours of firearms safety and proficiency training is generally required for an initial California CCW permit application? A. 4 hours. B. 8 hours. C. 16 hours. D. 24 hours. Answer: C. 16 hours. For an initial California Concealed Carry Weapons (CCW) permit, applicants are typically required to complete a minimum of 16 hours of firearms safety and proficiency training. This training must cover a variety of topics including safe gun handling, shooting fundamentals, and the legal aspects of firearm use. Always ensure your training course meets the specific hour and content requirements of your local issuing authority. Question 7. If you move from one county to another within California, what must you do regarding your CCW permit? A. The permit automatically transfers to the new county. B. You must surrender your old permit and apply for a new one in the new county. C. You must notify the issuing authority of your new address within 30 days. D. You can continue to carry in the new county as long as your permit is valid. Answer: B. You must surrender your old permit and apply for a new one in the new county. A California Concealed Carry Weapons (CCW) permit is tied to your county of residence, meaning if you move to a different county, your existing permit is no longer valid. You must surrender your old permit and apply for a new one with the appropriate licensing authority in your new county of residence. This ensures that the proper local agency retains jurisdiction over your permit and can evaluate your continued eligibility. Question 8. When is it permissible to use deadly force in self-defense in California? A. Anytime you feel threatened or uncomfortable. B. When you reasonably believe you are in imminent danger of death or great bodily injury. C. To protect your property from theft. D. To stop any person from committing a misdemeanor. Answer: B. When you reasonably believe you are in imminent danger of death or great bodily injury. In California, the use of deadly force in self-defense is strictly limited to situations where an individual has a reasonable belief that they are in imminent danger of death or suffering great bodily injury. This means the threat must be immediate and severe, not just a feeling of being uncomfortable or a threat to property. Understanding these strict legal thresholds is paramount for any CCW holder to avoid criminal charges. Question 9. Which type of firearm is generally not allowed on a California CCW permit? A. A standard semi-automatic pistol. B. A revolver. C. A short-barreled rifle, as defined by federal law. D. A compact handgun. Answer: C. A short-barreled rifle, as defined by federal law. California CCW permits are specifically for concealed handguns, and typically only handguns that are registered to the permit holder and listed on the permit are allowed. A short-barreled rifle is classified differently under federal and state law, is generally illegal to possess in California, and would never be authorized for concealed carry under a standard CCW permit. Always be aware that your CCW permit specifically authorizes only certain handguns you own and register on the permit. Question 10. When transporting a handgun in a vehicle without a CCW permit, how must it be stored? A. Loaded in the glove compartment. B. Unloaded and locked in the trunk or a locked container separate from ammunition. C. Loaded under the seat. D. Unloaded, but can be carried openly on the passenger seat. Answer: B. Unloaded and locked in the trunk or a locked container separate from ammunition. Without a Concealed Carry Weapons (CCW) permit, California law dictates strict rules for transporting handguns in a vehicle. The handgun must be unloaded and either locked in the vehicle's trunk or in a locked container, separate from any ammunition. This rule prevents immediate access to the firearm and reduces the risk of unlawful use. Always prioritize secure and legal transport methods if you don't have a CCW permit. Question 11. What is a key characteristic of good moral character as assessed during the California CCW application process? A. Having no prior traffic violations. B. Demonstrating a history of respect for the law and responsible behavior. C. Being actively involved in community service. D. Possessing a high credit score. Answer: B. Demonstrating a history of respect for the law and responsible behavior. Good moral character is a crucial criterion for obtaining a California Concealed Carry Weapons (CCW) permit, though it is subject to the discretion of the issuing authority. This typically involves reviewing an applicant's entire background, looking for a history of respecting the law, responsible behavior, and an absence of criminal activity, problematic associations, or a pattern of poor judgment. The intent is to ensure that only trustworthy and law-abiding individuals receive permits. Question 12. What action should a CCW permit holder take if their permit is lost or stolen? A. Immediately notify the issuing authority. B. Wait until renewal time to report it. C. Continue carrying without the physical permit. D. Obtain a new firearm to replace the permit. Answer: A. Immediately notify the issuing authority. If your California Concealed Carry Weapons (CCW) permit is lost or stolen, you have a legal obligation to immediately notify the issuing authority, which is your local sheriff's department or police chief. Prompt notification helps prevent unauthorized use of your permit and allows for the issuance of a replacement. Keeping your issuing authority informed of any changes or losses related to your permit is a sign of responsible ownership. Question 13. Which of the following is considered a common reason for CCW permit denial in California? A. Active membership in a firearm advocacy group. B. A history of domestic violence misdemeanor convictions. C. Being a registered voter. D. Not owning multiple firearms. Answer: B. A history of domestic violence misdemeanor convictions. A history of domestic violence misdemeanor convictions is a significant disqualifier for obtaining a Concealed Carry Weapons (CCW) permit in California, as it results in a lifetime federal prohibition on possessing firearms. Any conviction that prevents a person from legally owning a firearm will also prevent them from obtaining a CCW permit. Understanding these serious disqualifying factors is critical for any potential applicant. Question 14. What is the primary purpose of a CCW permit holder informing a law enforcement officer that they are carrying a concealed firearm during a traffic stop, even if not explicitly required by California law? A. To legally justify resisting arrest. B. To demonstrate knowledge of their rights. C. To prevent misunderstandings and ensure officer safety. D. To prove the permit is valid. Answer: C. To prevent misunderstandings and ensure officer safety. While California law does not explicitly mandate informing a law enforcement officer that you are carrying a concealed firearm during a stop, it is widely recommended as a best practice. The primary purpose is to prevent misunderstandings and enhance officer safety by openly communicating your status as a CCW holder, potentially de-escalating a tense situation. Always follow the officer's instructions carefully and avoid sudden movements when making this notification. Question 15. What are the renewal requirements for a California CCW permit? A. A new full 16-hour training course is always required. B. A shorter refresher training course, typically 4 to 8 hours, is often required. C. No training is needed for renewals, only an application. D. A psychological evaluation is required for every renewal. Answer: B. A shorter refresher training course, typically 4 to 8 hours, is often required. For the renewal of a California Concealed Carry Weapons (CCW) permit, applicants are typically required to complete a shorter refresher training course, usually between 4 and 8 hours. This is in contrast to the longer initial training requirement and ensures permit holders remain proficient and up to date on safety and legal aspects. Always check your local issuing agency's specific requirements for renewal training. Question 16. If a CCW permit holder encounters a "No Firearms" sign on private property, what is the legal expectation? A. The sign is advisory and can be ignored. B. The permit holder must comply with the property owner's wishes and not carry. C. The CCW permit overrides the private property sign. D. Only loaded firearms are prohibited by such signs. Answer: B. The permit holder must comply with the property owner's wishes and not carry. In California, property owners generally have the right to prohibit firearms on their private property, even if you possess a valid concealed carry weapons (CCW) permit. When a "No Firearms" sign is clearly posted, a CCW permit holder is legally expected to comply with the property owner's wishes, as carrying could be considered trespassing with a firearm. Respecting private property rights is an important aspect of responsible carry. Question 17. Which principle of self-defense emphasizes that the force used must not exceed what is necessary to stop the threat? A. Proportionality of force. B. Stand your ground. C. Duty to retreat. D. Objective reasonableness. Answer: A. Proportionality of force. The principle of proportionality of force dictates that the amount of force used in self-defense must be proportionate to the threat faced. This means you cannot use deadly force to counter a non-lethal threat, for example. The force must be necessary to stop the immediate danger, and using excessive force could lead to legal consequences, even if you were initially justified in defending yourself. Question 18. What is the legal implication of possessing a firearm that is not listed on your California CCW permit? A. It is perfectly legal, as long as you have a permit. B. It is illegal to carry that specific firearm concealed. C. It is only illegal if the firearm is fully automatic. D. It is legal to carry, but you cannot use it in self-defense. Answer: B. It is illegal to carry that specific firearm concealed. A California Concealed Carry Weapons (CCW) permit only authorizes you to carry concealed the specific handguns that are listed on that permit by their make, model, and serial number. Carrying any firearm that is not explicitly listed on your valid permit, even if you legally own it, constitutes carrying a concealed weapon without a license, which is a criminal offense. Always ensure all firearms you intend to carry are properly registered and listed on your permit. Question 19. If a CCW permit holder is involved in a self-defense shooting, what is the immediate recommended action after ensuring safety? A. Flee the scene immediately. B. Reholster the firearm and wait for law enforcement to arrive. C. Attempt to render aid to the assailant. D. Secure the firearm and immediately call 911 to report the incident. Answer: D. Secure the firearm and immediately call 911 to report the incident. In the aftermath of a self-defense shooting, after ensuring immediate safety, the CCW permit holder's immediate action should be to secure the firearm safely and call 911 to report the incident to law enforcement. Do not attempt to reholster immediately, alter the scene, or engage further with the situation beyond what is necessary for safety. Cooperate with responding officers, clearly state you were in fear for your life, and indicate you will provide a full statement after consulting legal counsel. Question 20. Under California law, a person with a history of involuntary commitment to a mental health facility may be prohibited from obtaining a CCW permit for how long? A. 1 year. B. 5 years. C. 10 years. D. A lifetime prohibition may apply depending on the circumstances. Answer: D. A lifetime prohibition may apply depending on the circumstances. Under California law, an involuntary commitment to a mental health facility can result in significant restrictions or even a lifetime prohibition on firearm possession and, consequently, on obtaining a CCW permit. The specific duration of the prohibition depends on the nature and length of the commitment. These laws are in place to ensure public safety by preventing firearms from being possessed by individuals deemed a danger to themselves or others. Question 21. What is the primary purpose of a holster when carrying a concealed firearm? A. To make the firearm easier to draw quickly. B. To prevent the firearm from being seen by others. C. To safely and securely carry the firearm while protecting the trigger guard. D. To protect the firearm from dirt and moisture. Answer: C. To safely and securely carry the firearm while protecting the trigger guard. The primary purpose of a holster for concealed carry is to safely and securely retain the firearm while protecting the trigger guard from accidental manipulation. A good holster prevents the firearm from falling out, keeps it in a consistent position for drawing, and, most importantly, covers the trigger to prevent negligent discharges. Always use a holster specifically designed for your firearm and carry method. Question 22. Which factor is considered when determining imminent danger in a self-defense scenario? A. The victim's subjective feeling of fear only. B. The victim's training and experience with firearms. C. An objective assessment of whether a reasonable person would perceive immediate threat of death or great bodily injury. D. The assailant's past criminal record, even if unknown to the victim at the time. Answer: C. An objective assessment of whether a reasonable person would perceive immediate threat of death or great bodily injury. In a self-defense scenario, imminent danger is assessed not just by the victim's subjective feeling, but by an objective standard. Would a reasonable person in the same situation have perceived an immediate threat of death or great bodily injury? This objective standard helps ensure that the use of force is justifiable and not based solely on unwarranted fear. Understanding this reasonable person standard is crucial for lawful self-defense. Question 23. Is it generally permissible for a California CCW permit holder to carry a concealed firearm while consuming alcohol? A. Yes, as long as they are not legally intoxicated. B. No, it is generally illegal to carry a firearm while under the influence of alcohol. C. Only if they are off-duty law enforcement. D. Only if the firearm is unloaded. Answer: B. No, it is generally illegal to carry a firearm while under the influence of alcohol. In California, it is generally illegal to carry a firearm while under the influence of alcohol or drugs, regardless of whether you have a CCW permit. This prohibition is in place to prevent irresponsible or accidental use of a firearm due to impaired judgment. Responsible concealed carry requires sobriety at all times when armed. Question 24. What is the consequence of failing to notify the issuing authority of a change of address within the same county for a CCW permit holder? A. No consequence, as long as it's the same county. B. The permit may be suspended or revoked. C. A minor fine will be issued. D. The permit automatically updates. Answer: B. The permit may be suspended or revoked. A California CCW permit holder is legally required to notify their issuing authority, sheriff or police chief, of any change of address, even if it's within the same county. Failure to do so can result in the suspension or revocation of your permit. Maintaining accurate records with your issuing agency is a critical aspect of responsible permit ownership. Question 25. What does the term "shall issue" generally mean in the context of CCW permits? A. The issuing authority must issue a permit if the applicant meets all statutory requirements. B. The issuing authority has discretion to deny a permit even if all requirements are met. C. The permit can only be issued to law enforcement officers. D. The state has no requirements for CCW permits. Answer: A. The issuing authority must issue a permit if the applicant meets all statutory requirements. In the context of concealed carry weapons, CCW, permits, shall issue, generally means that the issuing authority must grant a permit to an applicant if they meet all the legally defined objective criteria and statutory requirements, with little to no discretion for denial. While California has historically been a may issue state, recent legal decisions have shifted its practical application closer to a shall issue standard for qualifying applicants. Question 26. Which of the following is a common requirement for the type of firearms that can be listed on a California CCW permit? A. The firearm must be antique. B. The firearm must be on the California Department of Justice, DOJ, roster of certified handguns. C. The firearm must be a specific caliber, usually 9mm or .45 ACP. D. The firearm must be custom-made. Answer: B. The firearm must be on the California Department of Justice, DOJ, roster of certified handguns. California generally requires that handguns sold in the state for civilian purchase be on the California Department of Justice, DOJ, roster of certified handguns, often referred to as the DOJ roster. While there are exceptions for certain transfers, like private party transfers or sales to law enforcement, most issuing authorities will only allow handguns that are compliant with California law to be listed on a CCW permit. Always ensure any firearm you plan to carry is legal to possess and register in California. Question 27. What is the primary reason for a CCW permit holder to practice regularly at a firing range? A. To impress friends with their shooting skills. B. To demonstrate proficiency for permit renewal. C. To maintain and improve essential defensive shooting skills and firearm familiarity. D. To test new ammunition types. Answer: C. To maintain and improve essential defensive shooting skills and firearm familiarity. Regular practice at a firing range is crucial for any concealed carry weapons (CCW) permit holder to maintain and improve essential defensive shooting skills and firearm familiarity. Proficiency with a handgun degrades over time without practice, and the ability to safely and accurately deploy a firearm under stress is paramount for effective self-defense. Consistent training helps ensure you are prepared to react responsibly if a life-threatening situation arises. Question 28. In California, what is the maximum permissible magazine capacity for handguns possessed by civilians, generally affecting CCW holders? A. 7 rounds. B. 10 rounds. C. 15 rounds. D. No limit, if grandfathered in. Answer: B. 10 rounds. In California, the maximum permissible magazine capacity for handguns generally affecting CCW holders and other civilians is 10 rounds. Despite legal challenges, the general prohibition on magazines capable of holding more than 10 rounds remains in effect. CCW permit holders must ensure their firearms comply with this magazine capacity limit, as possessing high-capacity magazines can lead to legal penalties. Question 29. Which constitutional amendment protects the right of the people to keep and bear arms? A. First Amendment. B. Second Amendment. C. Fourth Amendment. D. Fifth Amendment. Answer: B. Second Amendment. The Second Amendment to the United States Constitution states, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. This amendment is the foundational legal basis for the right to own firearms in the United States, including for self-defense, and is frequently cited in legal challenges related to concealed carry. Understanding this fundamental right is key to understanding firearm laws. Question 30. When must a California CCW permit holder present their permit and a valid identification to a law enforcement officer? A. Only if they are arrested. B. Only if the officer specifically requests it. C. Anytime the officer asks for identification. D. Never, unless compelled by a court order. Answer: B. Only if the officer specifically requests it. A California Concealed Carry Weapons (CCW) permit holder is legally required to present their permit and a valid identification to a law enforcement officer if specifically requested by the officer. While you are not required to volunteer this information, you must comply if asked. Always be cooperative and follow all lawful instructions from law enforcement. Question 31. What is the duty to retreat concept in self-defense law, and how does California generally apply it? A. California requires a duty to retreat before using deadly force in all situations. B. California is a stand your ground state, meaning no duty to retreat exists. C. California generally does not impose a duty to retreat from an assailant in a place where one has a right to be. D. The duty to retreat only applies if you are outside your home. Answer: C. California generally does not impose a duty to retreat from an assailant in a place where one has a right to be. California law generally does not impose a duty to retreat from an assailant before using deadly force in self-defense, provided you are in a place where you have a legal right to be. This means you are not legally required to attempt to escape a life-threatening situation if you are otherwise justified in using force. However, retreat, if safely possible, can be a prudent option to avoid conflict, even if not legally required. Question 32. What is the significance of the Safe Handgun roster for CCW permit holders in California? A. It dictates which firearms can be carried concealed. B. It ensures all firearms on the roster have a manual safety. C. It is a list of approved instructors for CCW training. D. It lists firearms that can be purchased for personal protection without a background check. Answer: A. It dictates which firearms can be carried concealed. The Safe Handgun roster, officially known as the roster of certified handguns, is a list of handguns that have passed specific safety tests and are generally allowed to be sold by dealers in California. While not explicitly dictating what can be carried on a CCW, most licensing authorities will only allow handguns that are legally purchasable and registrable by civilians, i.e., those on the roster or exempt from it, to be listed on a CCW permit. Always confirm your firearm status with your issuing agency. Question 33. If you witness a crime while carrying concealed, are you legally obligated to intervene? A. Yes, as a CCW permit holder, you have a legal obligation to protect others. B. No, there is generally no legal duty to intervene in a crime, even when armed. C. Only if the crime involves another CCW permit holder. D. Only if law enforcement is not present. Answer: B. No, there is generally no legal duty to intervene in a crime, even when armed. In California, as in most jurisdictions, there is generally no legal duty for a private citizen, even a concealed carry weapons (CCW) permit holder, to intervene in a crime. While you may have a moral inclination, intervening carries significant legal risks and should only be considered if you or an innocent third party are in imminent danger of death or great bodily injury. Always prioritize your safety and call 911 immediately when witnessing a crime. Question 34. What type of background check is conducted for a California CCW permit applicant? A. A basic federal background check only. B. A comprehensive background investigation, including criminal history, mental health, and personal conduct. C. A simple credit check. D. Only a check of driving records. Answer: B. A comprehensive background investigation, including criminal history, mental health, and personal conduct. Obtaining a California Concealed Carry Weapons (CCW) permit involves a comprehensive background investigation. This goes beyond a simple federal background check and includes a thorough review of the applicant's criminal history, mental health records, and an assessment of their personal conduct and good moral character. This detailed process is designed to ensure that only responsible and law-abiding citizens are granted permits. Question 35. What is generally considered a negligent discharge of a firearm? A. Firing a firearm at a target during a training exercise. B. Firing a firearm in self-defense against an imminent threat. C. An unintentional discharge of a firearm caused by carelessness or improper handling. D. Firing a warning shot to scare off an assailant. Answer: C. An unintentional discharge of a firearm caused by carelessness or improper handling. A negligent discharge is an unintentional firing of a firearm that occurs due to carelessness, a lack of attention to safety rules, or improper handling. This is distinct from an accidental discharge caused by a mechanical failure. Responsible firearm ownership and concealed carry demand unwavering adherence to safety rules to prevent negligent discharges, which can result in serious injury, death, or property damage.